and we look at the matter of CB versus P.J.B. All of these acronyms, good grief, or all of these abbreviations, let's rather call it what it is. CB versus P.J.B. Bloemfontein High Court, summary page 7, bundle page 140, 6-page judgment under the pen of your Don A.J. Once again, Rule 43, spousal maintenance and a contribution to costs. The applicant sought, obviously, a contribution to costs and then maintenance pendente lite. The principles looked at by the court is essentially the core tenets as we've looked at previously. I'm not going to belabor it. Court found, obviously, that it's not intended to provide a long-term financial support mechanism, but to address immediate financial needs. Court emphasized the need for reasonable maintenance that reflected the genuine needs of the applicant and the financial capacity of the respondent. It is not just there for the asking in terms of a wish list. The respondent was ordered to pay 8,000 Rand per month maintenance pendente lite and a contribution toward the applicant's legal costs in an amount of 10,000 Rand. Now, in this case in particular, if one looks at the quantum of the maintenance that was ordered and the contribution to cost, the question obviously arises, why are these parties in the High Court and why is this not dealt with in the regional court? One can obviously only speculate in terms of the general consensus, which always comes up in these discussions. Is it for admin reasons? Is it for expeditiousness? Is it because there's a novel point of law? But very interesting, fairly low quantum Rule 43 in the grander scheme of things in the Bloemfontein High Court. The quote that we really need to look at in this one, nothing too new or strange for those of us who look at these types of matters on a monthly basis. The applicant, having established a need to maintenance and being unemployed, has clearly shown her inability to pay for costs of legal representation. Respondent in this regard makes respondent in this regard made an offer which is not keeping with the realistic rise in costs in having the necessary legal representation, and in the absence of the same, the aim of Rule 43 would be is skewed. My apologies for the typographical error there. That was copied straight from the judgment, so typo obviously on the judgment. Now, this is interesting in contradistinction with the very previous matter, also under your Don AJ, and you can see here the juxtaposition of a reasonable tender versus an unreasonable tender, and why it is so important to make sure that any tenders made in Rule 43 are scientifically and cleverly calculated. It is a very strategic move and a very important strategic consideration to make a tender in Rule 43 proceedings.